Good morning, sir. Are you Floyd Torrin?
Yes, ma'am. Good morning.
And Mr. Radford, will your client waive the formal reading of the indictment in each case?
Yes, ma'am, he will.
Mr. Torrin, in clause number 25 DCCR 0794, you're charged with a third-degree felony offense of attempt to commit theft or property from an ATM, and that's from May 10th of 2025. The indictment alleges in count 2 that you were convicted of the felony of possession of a controlled substance, a second-degree felony, August 16th of 1999. How do you plead to that charge?
Guilty.
And is that prior conviction true? Did you enter your pleas of guilty and freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they've charged you with? All right, give me just a second and I'll get that. The efficiency of going. All right, then, Mr. Torrin, in cause number 25 DCCR 1152, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from June 20th of 2025. The indictment alleges the same prior conviction of possession of a controlled substance in count 2. And how do you plead to that charge?
Guilty.
And again, is that prior conviction true? Did you enter your plea of guilty and true in this case freely and voluntarily, and because you did what they've charged you with? Each of these cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Radford? Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached in each of these cases is that, the agreement was that the state allowed you to plead only on counts 1 and 2. And that your punishment is the full range of punishment, which is a second-degree felony between 2 years and up to 20 years up to the court. Knowing that had you gone on the full indictment, you would be looking at a habitual status, which is 25 to life. Is that your understanding of your agreement?
Yes.
I want to make sure you understand you have every right to have a jury come in and determine 2 things. 1, if you're guilty or not, and then you could leave your punishment up to that jury. If we go forward this way, you're waiving that right and you're leaving it up to me, and also waiving your right to appeal as long as I stay within that 2 to 20 range. Do you understand? And is that what you want to do?
Yes, ma'am.
Do you also understand, sir, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objections.
It's admitted in each case. Is there any evidence that Mr. Torrin is not competent?
No, ma'am.
All right, sir. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Also find that you entered those pleas of true to counts 2 freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report. That'll give me more information about you, your cases, and then we'll come back later for sentencing. Anything that you think is important for me to know, be sure and get that information to Mr. Radford, and he'll get it to me so that I can review, and he'll present more whatever that day when we come back for sentencing. All right.
Judge, I'm gonna have some documents I will present.
Thank you.
I will
Thank you.
email them to Mark and CC Mr. Smith.
Okay. Make sure you get them to probation, and they'll attach them with the PSI as well.
Yes, ma'am.
All right. Thank you. You can go back with the bailiff.
May I be excused?
Yes, sir.
In this courtroom exchange, the defendant pleads guilty to 2 third-degree felony charges: attempted ATM theft and evading arrest with a vehicle, while also admitting a prior drug conviction. The judge carefully confirms that the pleas are made knowingly and voluntarily, ensuring the defendant understands he is waiving key rights, including a jury trial and the ability to appeal if the sentence falls within the agreed range of 2 to 20 years. This agreement also spares him from facing a much harsher habitual offender penalty of 25 years to life. After reviewing signed documents and confirming competency, the judge accepts the guilty pleas and orders a pre-sentence investigation report to gather more background information before determining the final sentence, with the defendant given a chance to submit additional materials through his attorney ahead of the sentencing hearing.